Thank you all for coming. I would note that most of the deans who have left the faculty here to become deans, with one major exception, Jim Ryan, who's now our president, they've also of late all been women. So we are not only the cradle of deans, but the cradle of female deans, which is very exciting. Welcome, everyone. It is wonderful to see you here. I couldn't agree more with Alex's description that this is just an extraordinary collection of scholars that has come together, and I'm so excited to talk with you today and to listen to what you have to say on this important subject. And this is not just one subject, actually. It's many subjects. Part of why Charlottesville became Charlottesville, which those of you who are coming from somewhere else, I think you'll notice we mostly here don't call it Charlottesville, because to us Charlottesville is many, many things. So we tend to call it August 11th and 12th. Because we don't want Charlottesville to be that. And when I speak publicly today, I hope I'm right about this, that Dana invited me as a scholar and not as a dean, so I'm going to speak mostly as a scholar, but I'll speak just a little bit as a dean first. But when I speak publicly about this, I always say, you know, right now Charlottesville is a lament, but I think it needs to be a rallying cry. And I think that part of today is Charlottesville becoming a rallying cry. And so when I think about all the different issues that are implicated by Charlottesville, by last August, by the neo-Nazis and the white supremacists who rallied here and the response to them, and why it became such an inflection point nationally and internationally, it's because it raised so many different issues of race, religion, ethnicity, and nationality, of gender, sexuality, pluralism and tolerance, politics and civic engagement and protest, social justice and economic opportunity, speech and violence, more and more. And like many of you, I have been thinking a lot about all of these issues in various ways and how to address them. For the past year, I've spent my time thinking about that, mostly not as an academic, but as chair of the university-wide response to what happened last year, and obviously as dean of the law school. In the latter capacity, we've had numerous events over the last year addressing in both direct and indirect ways what happened. We've had town halls and conferences. We've had opportunities for our community to come together and talk and support one another in both formal and informal settings. Just last week, we had a panel discussion on speech and dialogue and speaking and listening. What has really struck me, though, has been the incredible outpouring of energy and engagement around the university and around the law school by our students, our faculty, and our staff. I think people think about the response of the university as a top-down thing, but to me the response of the university has been all around the university by so many people who have been organizing, and that is nowhere more true than here, and the students who have organized many, many events and gathered allies and had dialogue, as well as our faculty. And those events are continuing. This month, the university has collected a series of events that began last night with the James Foreman lecture at the Paramount, and they will continue for the next month or so. So those of you who are local here, I encourage you to attend other related events across grounds. So today's event is obviously part of this outpouring of faculty response, an academic conference, and you've heard their names already several times, but I'm going to say them again, organized by Dana Matthew with Kim Ford-Mesrui and Josh Bowers, alongside their colleagues from other schools, Professor Osagi Obasagi and Dean Angela Nwachi-Willig. Congratulations. Are you here yet? Congratulations, another dean. And they have been organizing these gatherings on ECRIT for several years at different institutions, and I'll let Dana tell you more about that. But for my part, I'm so delighted that you all chose to organize your event here at UVA this year and around what happened last August, and so glad to see this incredible group of scholars here to enrich each other and our community and our students and faculty, and to do what we as scholars do most fundamentally to our mission, which is bring our intellectual resources to bear on the problems that we see in the law and the world, to research, to write, to create new knowledge that is relevant and meaningful, and then to share it with each other and with others. If you were at James Foreman's keynote yesterday, which I know some of you were, for me, there was really only one thing that I disagreed with in what he said yesterday, and that was that he said that law review articles don't change the world. And I beg to differ. Shocker. I actually believe they do. I think law review articles are one way that activism makes its way into formal legal processes, not the only way, but one way. They provide resources for lawyers, grassroots organizations, for judges, for activists, and they are actually, in my view, a key part of changing the world. But of course, I would think that. So in that vein today, we will put our intellectual resources toward identifying, as the conference organizers state, new tools to theorize, measure, and assess this nation's longstanding history and current struggles against racism, nationalism, and assertions of white supremacy. We will spend what I predict will be an intense and also very rewarding day examining, quote, structural forms of white supremacy that have produced racial disparities that remain embedded within the nation's justice, education, voting, and economic systems, institutionalized systems of oppression that are part of not only our history, but also our contemporary law and society. As a scholar, this is what I do, and I'm so pleased to be here today to speak and listen, not so much as a dean, but as a civil rights historian and a constitutional law scholar. I do want to say one thing as a dean before I start. So my talk today is going to be more on the resurgence of racism part than the reconciliation part, and I'm a hopeful person like James Foreman, but I'm going to go backwards, and so that's going to lead to a little bit less hope for most of my talk. But I do want to say as a dean that one of the things that we did last year that was not actually a response to August, because we had it planned from before August, but I think came to be part of our response to August anyway, was commemorate the first African-American student here at the law school, who was also the first African-American student anywhere in the university, and the first African-American university student anywhere in the former Confederacy at a white university. And his name is Gregory Swanson, and I say this was about reconciliation, and Professor Ford Mesri is nodding his head in the front row because he was a huge part of this, as was Diddy Morris, who I don't know if she's here on our staff in the dean's office. When for more than 60 years, the university did not really acknowledge Gregory Swanson, and it's because there were a lot of myths about his time here and why he left without a degree, and some of those myths cast aspersions on him for failure. Some of them cast aspersions on the university for pushing him out. It turned out the failure was the law schools. In the 1950s, our LLM program had people come for a year and take classes and then go back to practice and finish their master's theses, which no one did. So he was just like all the white people who came here and did that. So when our librarians and Gordon Hilton, faculty member who died last year, did all this research. I mean, I had committed actually to commemorating Gregory Swanson before we knew there was a good end to the story, but having a good end to the story actually made it easier. But the hardest part actually was reaching out to Gregory Swanson's wife and daughter, and they wanted to know why now, why are you doing this, what are your motives? We don't trust you. It's been a long time and nobody's ever wanted to commemorate him. And through a series of conversations, especially with Kim Ford Mesrui and Diddy, but also myself, I think they became convinced that we had good motives, and this was about reconciliation, and it was about acknowledging the white supremacist past of the university and the law school. And there's now a portrait of Gregory Swanson hanging in the library, and there is a small exhibit that our librarians have put together that they mean to go up a little bit later, but they put up today for you all, so I hope you'll go to the library and see his portrait and peruse it. We also have a new annual award that we give out so that his name is a name that becomes part of our culture and our community, and that every year people know who he was, and new students understand that they're walking his path. And by the end of the process, and Kim can tell you more, his wife and daughter said, you've really embraced him, and he's found a home here, and we're so glad we did this. And I think reconciliation is really the word of what happened between UVA Law School and this courageous, pioneering person who changed our law school and our university for the better. So I will offer that reconciliation story, and now I'm going to go to the resurgence of racism, or actually the continuation throughout American history of racism. So I see my role, my scholarly role, as providing some broad historical and legal context before the conference delves into each of the specific topics on the panels. For those of you who are the scholars here, a lot of this will be old hat, but my hope is to set the stage for members of the public and for our students who are not experts in this. And maybe there'll be a tidbit or two for those of you who know it all anyway. So 2 weeks ago, legal historian Vicki Wieste was here at UVA talking about August 11th and 12th and the history of anti-Semitism. And she described how last August, quote, connected our racist past to our racist present. And that is what I want to talk about today. I thought that phrase really captured it. Why did August 11th and 12th seem so surprising to so many people, though not at all surprising to so many others? And my answer is because of a series of disappearances and forgettings that have taken place over the last 60 years, beginning with Brown, but going right up through August 11th and 12th. And these disappearances and forgettings make it hard to make claims for racial equality, that these claims for racial equality and the changing nature of racism and racial inequality struggle against narratives that were created and legal interpretations that were always partial. And these narratives and these forgettings not only make it hard to struggle for racial equality, but pave the way, inadvertently or advertently, I'll leave that to you to decide, for some of the claims of white supremacy that we saw on August 11th and 12th. Okay, the first disappearance, and the one that set the stage for all of the rest, and the one I'll spend the most time on, is the 1954 case of Brown versus the Board of Education. Brown was a victory for civil rights in many ways, but as cases do, this case did a lot of different things, right? When we say case, we actually mean lots of different things, right? We mean a doctrinal holding. Brown made racial segregation in education unconstitutional as a matter of its holding. We also mean an historical moment. So Brown represented a turning point from Jim Crow to racial equality. We also mean a political intervention. The Supreme Court sided with the NAACP over and against Southern states. Of course, Brown only partially ended Jim Crow as both a legal and a historical matter. It was one step in the elaboration of a legal doctrine that took decades, and much litigation and legislation was required actually to achieve integration, and even then, that integration was only partial and in many ways temporary. But in other ways, it wasn't just that Brown was partial or only one step. It was also that Brown served to disappear certain parts of its own history. So in addition to being a holding and a historical moment and a political intervention, every case is also a refracted image of reality. It offers a vision of the world into which it intervenes and the world that it aims to create. And the vision of Jim Crow that Brown offered actually obscured a lot of what Jim Crow was. To understand what I mean, I think you have to go back to slavery, because Jim Crow was an eventual contingent replacement for slavery. Slavery was a system of racial oppression, exclusion, and denigration, not to mention simply horror. It was also a system of economic exploitation. It was many systems. It was a system of reproduction, which I'm sure will come up later today, but I want to focus on the economic exploitation and the deep-seated material inequalities that went along with it for now. They're the systems, the aspects of the system I know best other than racial oppression, the ones that I have written about. So when slavery ended and Jim Crow eventually replaced slavery, Jim Crow was also a system of racial oppression, of separation, of discrimination. And it was simultaneously a system of economic exploitation and purposeful and sustained material inequality. African Americans living through Jim Crow knew this. They complained about it to lawyers in the NAACP and the Department of Justice, among other organizations. When they asked for legal redress, they asked both for an end to formal government-imposed segregation and government-supported and private forms of economic inequality and exploitation. The cases in the decade before Brown took up that challenge, that dual challenge of race and class, and explored the possibility of undermining Jim Crow through the 13th Amendment as well as the 14th, in labor unions and employment as well as education, in achieving material equality as well as formal desegregation. The good lawyers that they were, the members of the NAACP and its Legal Defense Fund pursued their school desegregation strategy, ultimately focusing their legal question and their legal case, as cases get focused in the process of litigation strategies, more and more sharply on the formal racial segregation component of Jim Crow. The focus became equal protection, and the focus became formal equality. There are many, many reasons for that, and I won't go into them now, but these were excellent lawyers, and they made excellent choices about how to pursue their litigation strategy. But that said, the image of Jim Crow that came out of Brown made Jim Crow look as if formal segregation was its entirety. And it lost the other half, the private economic inequality, whether redressable under the 13th Amendment or the 14th Amendment. And as so many treated Brown as an authoritative cultural text as well as a legal decision, people often took their image of Jim Crow from that opinion, and it made the other half of Jim Crow harder to see. It came to limit our imaginations, not inevitably, but contingently, for the constitutional redress of material inequalities, and led us to believe, leads us today, I think, many, I'm not included in this, obviously, but I think it leads many Americans to believe that if there continues to be racially inflected economic inequality in our world, they are happenstance and contingent rather than the continuation of the system of Jim Crow. So once you see Jim Crow in its entirety and see that it was necessary for the litigation strategy to attack only a part of it, and see that when the court described it, they described only a part of it, you can see how we ended up with some disappearances and some forgettings. So a case is a political intervention, a doctrinal holding, a moment in history, a refracted image of reality, and it's also, and very fundamentally, a form of legal reasoning. And in its legal reasoning, Brown focused very much so on the existence of segregation alone as the rationale for finding a constitutional violation under the Equal Protection Clause. And that made sense. It made a lot of sense, especially in the context of Plessy versus Ferguson. One had to prove that racial segregation, even in the absence of material inequality, caused harm, because Plessy's claim had been that racial segregation alone did not cause harm unless an individual African American allowed it to cause that harm. That's why the doll studies were so critically important to the case, to prove the harm. But in the process, the court stripped out and in fact stipulated that material inequalities often go hand in hand with formal segregation. Now, I think the NAACP lawyers believed that material equality would follow from desegregation. And that was possible, but it's not what happened. Indeed, Brown itself was fairly unclear, Brown the opinion and its legal reasoning was fairly unclear about exactly what the harm was and exactly what the nature of redress should be. Chief Justice Warren was adamant that this be a unanimous opinion, adamant, persuasive, he aspired to it, and he also wanted this opinion to be on the front page of the New York Times. He wanted it to be short, he wanted people to read it. As a result, the opinion left a lot to be desired. Unanimous opinions can't always say all that much, especially in controversial cases, and if you really want people to read them, they also can't say that much. So it left open, in my view, the question of what the real harm is in segregation or discrimination. Why does segregation or discrimination violate equal protection? And there are two possibilities that many of in this room have written more about than I. One possibility is that the harm of segregation and discrimination is that the government is thinking about race. The government is classifying people on race. The government is acting on the basis of race, and that that's a dangerous thing. That we've seen what happens when the government does so. We've seen slavery, and we've seen Jim Crow, and the government has to get out of the business. The alternative is that there is racial inequality in the world, and when the government ignores it, It violates the Equal Protection Clause. We live in a world of inequality, and the government must act. Those two approaches to what the Constitution protects under the Equal Protection Clause have come to be known as the anti-discrimination or anti-classification view on the one hand, and the anti-subordination approach on the other. In the anti-discrimination or anti-classification approach, the problem is differentiation on the basis of race. All racial discrimination is equally problematic, regardless of whom it serves and whom it victimizes. Under anti-subordination, that is not the case. Anti-subordination, as its name suggests, takes power and balances the world in the world as a given and assumes that the government has to act to end them. Brown is often read today, especially by majorities at the Supreme Court, as embracing the anti-discrimination approach. And one can clearly see it there, and there is a reason that they call Brown on their own side. On the other hand, I think you can also see the anti-subordination alternatives. And I'm going to see, I don't know, I think this might be the most controversial thing I say today, but I could be wrong about that. To me, I see real anti-subordination implications in Brown 2. Brown 2 is the second case that followed on Brown 1, where the court thought about and answered the question of remedies. And Brown 2 is rightly exhoriated, for its all-deliberate speed slowdown of the process of desegregation. But here's the thing that's always puzzled me. If all the court thought was necessary to remedy segregation was formal, official desegregation, was removing laws and stopping the government from thinking about classifications, why would that take any time at all? The court was clearly thinking that desegregation required new attendance zones, new buses, new books, new teacher assignments, right? What was going to take so long if all you had to do was remove the laws from the books? Brown 2 presumed real transformation, real desegregation, real change in the material fortunes of African American children in our public schools. So I think the legal reasoning in Brown offered up the possibility of undermining both Jim Crow's legal segregation and its material inequality. And future activism and future cases and future scholarship continued in that vein. But all of those people who continued on articulating the anti-subordination view and fighting to make Brown both a material reality and a formal legal one had to fight against the refracted image of reality of Jim Crow that the case had reflected. And they had to fight against the historical narrative of triumph that accompanied Brown. I'm going to talk about that more in a minute. I've spent a long time on Brown because it's such a critical moment, and the image that it created and the narrative that it ultimately spawned unwittingly and unintendedly created real obstacles in the service of equality. This moment was followed, of course, by many others. It was followed by those who implemented Brown, by those who made real the change that Brown aspired to, by the incredible courage of African Americans and their allies, by the real and enduring change that they managed to bring about with extreme and often even the ultimate sacrifice of their lives. But as they struggled repeatedly against the appeal of the anti-discrimination framework. The March on Washington of 1963 was a march for jobs and freedom, but the emphasis in the public narrative was far more on freedom than on jobs. Another disappearance, another forgetting. When Congress, in response to these massive civil rights protests, passed the Civil Rights Act of 1964, that act continued the anti-discrimination slant. It provided a right to employment without discrimination. It did not provide a right to employment. In the 1940s, there was talk of full employment. There was not talk only of a non-discrimination employment. And this is particularly ironic and rich and tragic because, as James Foreman mentioned yesterday, at the very moment that the Civil Rights Act of 1964 was passed, all the good jobs were disappearing from the North and from the Midwest. And so the very jobs that could have been had, perhaps now, on an anti-discrimination basis, were gone. And more than ever, we needed to think not only about anti-discrimination, but about subordination, not only about formal racism, but about economic exploitation. It was a victory, to be sure, just as Brown was, but less thoroughgoing than one might have hoped. Another disappearance. The Civil Rights Acts of 1964 and 1968, and the Voting Rights Act of 1965, and especially the 1964 and 65 Acts, unwittingly gave a narrative bookend to Brown. Between 1954 and 1965, the civil rights movement triumphed, this narrative suggests. It ended formal segregation, it ended Jim Crow, and it left all Americans on an equal footing. The civil rights movement had ended overt white supremacy. All Americans were now agreed in the basic humanity and equality of all, and all had the same chances in life. Racism was something in this narrative that was a result of intended actions by individuals, and the law had now outlawed them, and they were gone. Jim Crow was a system only of formal segregation in the South, and the law had ended that. Another forgetting. The popular history of Martin Luther King Jr. has often been offered along similar lines. He is remembered for condemning differences of treatment on the color of people's skin, but he was also, as James Forman and Michelle Goodwin both reminded us yesterday, deeply concerned about poverty and economic inequality. Those ideas of his, especially later in his life, and his activism around the poor people's movement falls to the wayside, because by setting those aside, we make him a victor. And he cannot be a total victor if his concerns went to poverty and went to racially identifiable poverty, because those still exist. Another disappearance. The narrative about our civil rights history, the goals of the freedom struggle, and the beliefs of its leaders have cabined what Jim Crow was, and therefore circumscribed what and how much was necessary to change in order to create real equality. This narrative undergirded further doctrinal development of the Equal Protection Clause. It facilitated and went hand in hand with the increasing dominance of the anti-discrimination approach to the clause and to our Constitution. The idea that Brown and the Civil Rights Act of 1964 had finished the work of ending white supremacy and Jim Crow meant that what remained to be done was beyond the ken of the law. The law simply had to be neutral as between the races, and the races would essentially be equal in the world. That was never entirely the case. The anti-discrimination approach to equal protection has never triumphed. That remains to be seen whether that continues. But I will just put out there the fact that we allow for disparate impact claims in some of our legislation, the fact that there do remain affirmative action claims that can be made, means that anti-subordination is still out there a little bit. It's deeply circumscribed. It's circumscribed by the refusal to allow for disparate impact claims in constitutional law under Washington versus Davis. The Constitution doesn't require the government to redress inequalities out there in the world. And even in those circumstances where it allows the government to do so, the increasing limitations on affirmative action, that we can no longer talk about government action that thinks about redressing society inequalities. We have to speak in the language of diversity, that we're no longer even allowed to remedy much past societal discrimination, or even in cases like parents involved in Shelby County, continuing structural and institutional discrimination. Those are more disappearances and more forgetting. So efforts for racial equality are always struggling against this dominant narrative. And so many people, I'm assuming all of the scholars in this room, have struggled against that narrative, as well as so many historians, legal scholars, activists, and lawyers outside of this room who continue to articulate the continuing harms. The lawyers and legal scholars have made the case for covert, unconscious, institutional, and historical racism and white supremacy. It is possible and has been possible to see the racism, see the inequality, but as legal scholars, it has been a challenge to make it legally and constitutionally cognizable, a challenge that many of us have taken up. The historians, for their part, have argued that the quest for equality began long before Brown and encompassed the North as well as the South, the West as well as the East, economic inequality as well as racial segregation. There are so many different efforts to make visible once again what had often been disappeared through a process that was by turns intentional and unintentional and deeply contingent at many moments. So I am guessing that few people in this room, and few African Americans anywhere, were particularly surprised by the white supremacy that reared up violent and deadly last August. Even if one might have been surprised, or perhaps the better word is shocked, right? Not surprised, but shocked by the particular form that it took, and horrified by that form and by the violence that it did. We would not have been surprised by the continued existence of racism, though, and the deep embeddedness of white supremacy. Those remain, despite Brown, despite 1963, despite the Civil Rights Acts, because they had never been truly uprooted. But it was a surprise to many, because all that had disappeared, because of so much that could no longer be remembered in the dominant stories we tell about ourselves. As James Forman said yesterday, we all like to think of ourselves as good people. And for many Americans, that meant thinking that white supremacy was part of our past and not our present. And our historical narratives and our legal doctrines allowed us to affirm that belief. They, in fact, made that belief possible. And so those disappearances created surprise where none should have been. The confirmation last August that the most visible form of racism exists shows what you all have been studying and saying for decades, that racism and white supremacy persists, that it is not an equal society in which this type of racism, this type of violent and virulent racism episodically shows up out of nowhere, right? It is actually showing up because it is there all the time. So August doesn't tell us that there is racism. August, I hope, tells us we were right to think there was racism here all along, but makes it more visible to those who could not see it because of these disappearances and these forgettings, and makes it all the more important for us to continue to use the tools that we have been developing over these years. It doesn't make those tools unnecessary, it makes them all the more important, which I'll come back to in a second. I want to go one step further along the idea of consequences intended and unintended. So just as these disappearances and these forgettings made it harder for activists to pursue equality, at the same time, it gave new tools to white supremacists. While some groups and individuals who were here last August and exist elsewhere identified themselves as white supremacists who advocated and advocate various forms of racial and religious genocide, that was not the only language one heard last year. Jason Kessler and others used particular language that commentators have sometimes adopted, that they are merely white advocates fighting for white rights. That term, those terms, white advocate, white rights, sound in a jurisprudential and historical framework purposefully and specifically different from that of white supremacy. They assert and assume that white advocacy can be on a par with black advocacy, and that the two are moral equivalents, that whites are simply another group of racial victims protecting themselves. It is the neutral anti-discrimination world made by the disappearance of caste, subordination, history, and power that makes that claim possible. It is the same neutrality that disappears the continuation of white supremacy that makes it possible for white supremacists to lay claim to having their own rights. In an anti-subordination world, in a world where we acknowledge the power differentials, where we acknowledge the history, where we acknowledge caste and subordination, that claim is not possible. And let me be clear, I'm not saying that those who argue that they are white advocates and white rights protectors are not white supremacists. They are clearly white supremacists. They are using this language instead of that language because it resonates with the constitutional frameworks that have been created. So as I noted at the outset, this talk has been longer on the resurgence or the continuation of racism than on reconciliation. But I do want to end on a hopeful note because like James Forman, and despite the critical cast of this history, I am hopeful. James spoke yesterday about the myths of black criminality and violence that have persisted for hundreds of years and that color, no pun intended, so much of what we see and how we see it. And he pushed us to identify those myths and not fall prey to them. So I want to suggest the same here. My goal here is to call on us to take this moment, as we have taken so many others, when the racism that has been harder for some to see has gained new visibility, to remember all that has disappeared, to recast the historical narrative, and to ask anew what role the law has played in bringing us to this moment, and what role it can and must play in moving us forward once again. That might sound like a feeble call or a dry one or an unduly scholarly one, but to me it is not. It is profoundly important. The stories we tell and the harms our laws can see, acknowledge, and redress are crucial, and they are urgent. I was struck at a law school panel shortly after last year's events when somebody referenced the white supremacists and neo-Nazis as unpopular minorities. In the stories I tell, in the history that I study, in the 1950s and 60s, the time we've been discussing, it was the civil rights activists who were the unpopular minorities, and the white supremacists who were the dominant majority. When I heard that phrase applied to the white supremacists, I was gratified to think that that has flipped, and that despite the politically fractured world that we live in today, even that Congress unanimously denounced the white supremacy here in Charlottesville. At the same time, I find it scary to think that these white supremacists are now unpopular minorities, and once before it was African Americans and their allies who were the unpopular minorities, because I have watched how that change happens and how a group goes from being an unpopular minority to a dominant majority. That is what I write my scholarship about. And I know that change doesn't always happen in one direction, and it doesn't always happen for the better. Change happens for the better when we make it so. And conferences like this one, and the law review articles like those that will come out of this conference, are a crucial part of that. I cannot wait to hear what you all have to say throughout the day today, and to watch what happens in the years and decades after you put it into print. Thank you.